Welcome everybody, and thank you for joining us today. Today's webinar will be presented by Kirk Cullimore Sr. and will be discussing the impact of federal and local COVID-19 legislation on the apartment rental industry in Utah. My name is Brenda and I'm the office manager. Kirk has asked me to assist with this presentation. This webinar is presented for informational purposes only and is not intended as legal advice. Since every situation is fact-specific, the information in this webinar should only be used in conjunction with proper legal counsel. The information that will be presented is current as of today, April 6, 2020. Since this situation is changing rapidly, please keep up to date with our latest COVID-19 guidance posted on our website or call our office. If you have questions during the webinar, please use the Q&A feature at the bottom of your screen to type your question. We'll try to answer your questions by typing back a response, or Kirk will answer your question live. Please only use the chat feature for technical difficulties. There will be a brief question and answer session at the end where remaining questions will be answered as time allows. If you have a unique situation or feel like your specific question was not addressed, feel free to contact our office afterwards. If you'd like to review this presentation later, the recording of it will be available to you by tomorrow, signing into your account at cullimorelaw.com. We'll now turn the time over to Kirk Cullimore Sr. for the presentation.
Okay, well, give me a second here. I've got to make sure I do this right and share my screen with you so we can get this started today. Well, I appreciate the opportunity to be here today and talk with you all. I hope that we answer your questions well. I hope this presentation will help you a lot in understanding where we're at. As you all know, this is a fairly fluid situation, and so as events occur, and they seem to occur daily, we'll try and keep you updated by sending out emails and rent alerts that give you that information. So I'd encourage you to look at our website as frequently as you can and make sure that you have the most current information that we can give to you. With that, let's get started and talk about what we've got going on here today. We're going to start by talking about the Federal CARES Act, which is the Coronavirus Aid, Relief, and Economic Security Act. This is an important act that was passed by Congress last week and provides a lot of stimulus relief and other relief to people that are affected by the COVID virus. This act is a couple hundred, well, it's like 800 pages long. And there's two provisions of it that deal directly with our industry in terms of how we can either get benefits from our lenders or how we are going to be restricted from doing evictions. In all events, when it relates to the apartment industry particularly and to landlords, it talks about what's a covered property. And so we want to talk today about what a covered property is and kind of give you some guidance on what that means and whether you're a covered property or not. And it's important that you know that. And if you don't know it and we don't answer your question today on whether you're a covered property or not, then you're going to need to take some time to either talk to your regional managers, your owners, somebody that has enough information to know whether you're going to be a covered property. So let's start with the simple ones. You're a covered property if you're involved in a HUD program, including Section 42, Section 8, although we believe at this point, if you have Section 8 units, that this only applies to those specific units. They haven't given us guidance yet on whether this would apply to the entire property. We believe from a logical standpoint, and we're dealing with the government, so logic may not apply, but from a logical standpoint, it would only apply to the unit that is covered under Section 8, not the entire property. And of course, any property that was covered by VAWA. And so if previous to this time, if you had any of your property that was covered by the Violence Against Women's Act, then the CARES Act is going to cover your property. If you're involved in any of the rural housing programs that HUD has instituted, then you're a covered property. Finally, the last part of it that covers most of you, or at least many of you, is properties that have loans that are backed by the federal government, particularly through Fannie Mae and Freddie Mac. As we talked with the National Apartment Association and with other bankers, we determined that probably about 70%, and maybe a little bit higher in Utah, of all multifamily properties have either a loan through Freddie or Fannie, or have a loan that is guaranteed or somehow supported through those programs. If you are supported through those programs or have a loan or a loan guarantee through Freddie Mac or Fannie Mae, then the CARES Act applies to you. And it's important to know whether the CARES Act applies to you, and you're going to see that as we talk about this today. So as it applies to apartment communities, the federal CARES Act enacted a moratorium on evictions for covered properties. This moratorium started on March 27th of 2020, and under the act will end on July 25th, 2020. This moratorium is only for two types of evictions: anything that deals with the non-payment of rent and end of term. And so if you have somebody who is going to have their lease expire, you cannot serve an end of term notice during this covered period. It also prohibits you from charging late fees or other penalties relating to the non-payment of rent. So anything to do with the non-payment of rent, if you are a covered property, then you have to comply with the CARES Act. So let's talk about some of the specifics on this. For pay or vacate issues in the state of Utah, you cannot, this applies to any amount that is owed under the lease agreement. So it doesn't just apply to rent. It can apply to any fees, utilities, anything which the landlord is charging on a monthly basis to a tenant under the lease agreement would be covered under the CARES Act. You cannot charge any late fees. You can't charge concession chargebacks or other penalties for non-payment during this time period from March 27th until July 25th. And because of the way it's written and because of Utah's laws, it doesn't appear that we can even serve pay or vacate notices until July 25th. We're hopeful for some clarification on this, but at this point in time, our advice is to not serve pay or vacate notices until July 25th. Utah has a similar order out right now, and we don't want to confuse the two too much. And so I want to make sure you understand that our governor's order that came out late last week is different than the CARES Act. Quite frankly, if you are governed by the CARES Act, then the governor's order is pretty meaningless to you because it really doesn't, you're already restricted from things that the governor says you can do or you shouldn't be doing. And so if you are covered by the CARES Act, the only thing the governor's order did for you really was encourage people to come talk to you, I hope, to enter into some kind of deferment agreement or discuss how they're going to make payments. If you're not covered by the CARES Act, though, then the governor suspended the filing of pay or vacate evictions in the state of Utah until May 15th of 2020. However, that suspension is only for payments that were required to be made after April 1st. So to qualify for this under the governor's order to not be evicted for a pay or vacate, you had to be current on your rent as of March 31st, and you have to suffer a loss of wages or job as a result of the COVID-19. Now, when the governor came out with this originally, there were a couple other requirements, And as they discussed it and decided to come out with the final order, it got consolidated to just this one issue, that they have to either be, they had to have been current on their rent, and they have to suffer a loss of wages or job as a result of the COVID-19. The other requirement was in there was if they were going to be quarantined or actually had the COVID virus, and it was kind of determined that if they had the COVID virus or were quarantined, they were going to suffer a loss of wages or job. And so it was all kind of inclusive in the number two that we have on this. And so those are the two requirements in order to qualify under the Utah provisions. So if you're not covered by the CARES Act, then you need to look at the governor's order to determine whether you can do pay or vacate evictions. The order that the governor issued specifically stated that it does not apply to commercial properties, that it doesn't prohibit evictions for any other purpose, it doesn't create, require, or imply rent forgiveness, or excuse or otherwise relieve an individual's obligation to pay their rent. Now, this was a great thing for us in the industry that the governor came out with this, because it came out after the federal law, and a lot of people thought, oh, I'm excused from my rent, or I've got rent forgiveness. And I think that the governor coming out with this order and clarifying his order with these provisions in it has encouraged tenants, or at least will encourage tenants, to come in and talk with us about their problems and whether they have the ability to pay rent or not. Also under the Utah provisions, and again, this is Utah, so if you're covered by the CARES Act, this doesn't apply to you. In order for a resident to not be evicted and not get a pay or vacate, have a pay or vacate eviction, they still have to come in and talk to you, because they have to supply the information. They have to still apply for this deferral of rent that they are going to ask for. And we're still entitled to documentation to establish that they meet the requirement that they've had a effect on their income as a result, or the loss of their job as a result of the COVID-19. If we receive documentation, we don't think it's sufficient, we technically can apply to the Department of Workforce Services for a mediation on this. From a practical standpoint, I'm not sure that is a good thing to do, because by the time we get the mediation and workforce services, and after we've gotten the documentation and discussed it with our clients, we may be at the end of the month anyway, and can start our eviction on May 15th. And so there's some issue whether or not that's going to help us at all in the process here. If you have a case where you don't believe they've met their criteria, call us so we can talk with you about it, and we'll help you make the determination whether to go to workforce services or not. In any event, you should still be requesting a deferral agreement for anybody that comes in and wants a deferral under the Utah law. But if they refuse, there's not much you can do other than determine whether they qualify or not. Again, it doesn't require them to sign a deferral agreement, but we'd like them to. It would help it. One of the great things about the Utah law, again, it doesn't waive late fees or other fees. And so if you're covered by the CARES Act, this doesn't apply to you, but if you're only covered by the Utah law, then you can still charge late fees and other fees. Remember that neither the Federal CARES Act nor the Utah order grant any rent forgiveness. They are getting a portion of forgiveness under the CARES Act in that they don't have to pay late fees. But rent is not being forgiven. It is merely being deferred. And so neither of the two acts give any rent forgiveness. Now, if we get back to the Federal CARES Act, it also has a moratorium on serving non-renewal notices, end of term notices, or notice to vacate as a result of an end of term. Under the CARES Act, we can't serve these notices until July 25th, 2020. So if somebody's lease is becoming expiring in 30 days or 60 days, you cannot serve an end of term notice on them until July 25th. And so if your lease agreement requires you to give a 60-day notice, then on July 25th, you can give a 60-day notice, but that means that they will have August and September in order to vacate under that end of term notice. If your lease allows for a 30-day notice, then you can serve it on July 25th and have them out at the end of August. One of the other provisions of the CARE Act, again, this is only if the CARE Act applies to you. So if it doesn't apply, none of this matters. But another provision says that 15-day notices are now out the window for the rest of 2020. We cannot serve a 15-day notice even though state law allows for a 15-day notice when somebody's on a month-to-month tenancy. All of our notices have to be at least 30 days, and if your lease agreement provides for a longer period, then you have to give it to them for that longer period. And remember, these cannot be served during the March 27th to the July 25th time period. They can only be served after that time period. So what can you do if you're covered by the CARES Act? Well, you can sign deferral agreements, and we encourage you to do that. We think the deferral agreements are an important part of management at this point in time for this next 120 days. A deferral agreement encourages the tenant to pay, and it gives us an opportunity to have an open discussion with them on what they can do and how they can pay. And so we'd encourage you to try and get your tenants in to sign deferral agreements and encourage them to abide by those deferral agreements. We can do settlement agreements if there's other things going on that we're trying to settle. And particularly if it deals with non-payment of rent issues, we should be doing settlement agreements in order to give us other opportunities to take care of people that aren't paying their rent. So if somebody's not paying their rent, they do something that breaches the agreement, a settlement agreement may give us rights to evict where we wouldn't have had those rights under the CARES Act. And so talk with us and we can help you draft those in a way that may give us some opportunities during this 120-day period that we have to not be able to do non-payment evictions. We can serve nuisance notices. We can serve comply or vacate notices. We can serve notices to vacate for criminal activity. None of those are prohibited under the CARES Act. And of course, none of them are prohibited under the Utah order either. And so we should be managing our properties pretty much the same as we've always managed them for nuisances. Maybe even being a little bit more aggressive on nuisances, because if somebody isn't paying their rent and they're a nuisance, we may decide to take faster and more decisive action based on the nuisance because they're not paying their rent either. We can still file lawsuits on eviction notices that were served prior to March 27th. So if you served an end of term on March 15th that it's going to expire on June 30th, we can still do that end of term because it was served on them prior to March 27th. So end of term notices that were served prior to March 27th are still effective notices, and we can still file evictions under the CARES Act for notices that were served prior to March 27th. We can still do new renewals. We can increase rent based on those renewals to the market rate. We can charge month-to-month fees for tenants when they reach the end of their term if we determine that we aren't going to renew their lease. We need to be a little careful on these month-to-month fees in that we can't make them look like a penalty. So if they're going on a month-to-month tenancy because we choose not to give them a new lease agreement, that may look like a penalty under the CARES Act, and we may not be entitled to charge a month-to-month fee. But if they elect to go on month-to-month, we can charge the month-to-month fee if it's provided in your lease agreement. And we can clearly charge the market rate that we would have charged a new tenant coming in when their lease expires. You still need to mail out the notices on a timely basis. It says your lease is going to expire on this date, and this is what your new rental rate is going to be, and have all the proper information on that. But we can do those things under the CARES Act. We can charge NSF fees. If they bounce a check that doesn't relate to the non-payment of rent, that's a new fee, and so we can still charge those kind of fees. We can serve balance due notices. And so even though we can't serve pay or vacate notices, we can serve notices that tell the people that they have to pay their rent. And we've produced a couple of these on our website for you, and you can use those or modify them to meet your needs. But these are a little bit more than a reminder notice. One of them is kind of the first tier nice notice that we're just saying, hey, please make your rent payment, that you're in default of your rental agreement. And even though we may not be able to file eviction, you're still in default. The second tier one talks more about, we may have a policy, and we may encourage you to do a policy that says that people that don't come in and talk with you about the non-payment problems, that we may not let them have a payment arrangement at a later date. And so the second tier notice is a little stiffer, a little tougher, and we'd encourage you to keep serving notices to remind people that they owe their rent, and try and encourage them to pay their rent. We can get updated application information, and we should use this time period to update those applications and should require it when they sign a deferral agreement. We should be asking them about their job and whether they still have it or whether they've just been temporarily laid off or furloughed. We should be using this time period where we are going to be less actively involved in notices and evictions to update our files and look at those things. And again, we can be less forgiving on nuisance issues as a result of it. Going back to the Utah eviction order, the governor's eviction order, what we can do, if you're not a covered property under the CARES Act, is you can still serve pay or vacate notices. So if they don't pay their rent on April 5th and you haven't signed a deferral agreement with them, you can serve your pay or vacate notice. We can still serve all the other notices that we normally serve. Matter of fact, pretty much whatever you were doing before this pandemic, you can still do, except we can't file an eviction case until May 15th. And for rent that's due for April and May. So basically, if you're not a covered property under CARES, the only thing that this is doing to us is we can't file an eviction case until May 15th. So let me give you a little update on what we've been working on the CARES Act a little bit. Both the National Apartment Association and the National Multi-Housing Council have been working with Congress to get better clarity on this CARES Act. We were really disappointed, quite frankly, when it came out that it had a 120-day moratorium. We are more disappointed that it didn't clarify that this moratorium should have only applied to people who were affected by the COVID-19. As most of you know, a majority of your tenants still have their job or are being paid at least by their jobs. A majority of your tenants, even if they lose their job by the middle of April, will receive enough unemployment and other benefits from the government that they should be able to pay their rent. We were hopeful that the CARES Act would give us more teeth in order to require that those payments be made when they start receiving their income. It didn't. But there is another bill that's in process right now in Congress. We've been talking with our legislators, we've been talking with people, and hopefully we'll see some clarification of this by the end of this month, or at least early in May. If we don't, we don't. From a practical standpoint, I'm encouraging you not to expect there to be any changes. This is going to be our life for the next 120 days. If we get something, we'll all be pleasantly surprised and be able to get back to some normalcy in this. My expectation is this is what we've got until July 25th. And so, although we're being actively engaged in trying to fix this, it may or may not happen, and I'm anticipating it's not going to happen. So let me give you some practical considerations that we talk about, that we need to talk about when it comes to evictions. We have quite a few evictions in the courts right now that were filed long before this COVID-19 crisis occurred. They are filed in early March and mid-March. The courts have been slow. Some of the counties have been better than others. Salt Lake County has been particularly slow. We've started to see some movement today as a result of the governor's order last week that basically said that this should only have an effect on evictions that were not related to rent before the April 1st. That being said, we've seen some of the judges already say that because of the governor's order to stay home and stay safe, and it looks like most of it's being extended out until about May 15th, that we're getting some eviction orders that are not allowing us to do the eviction until May 15th. Now that's not consistent across the board, but you need to be careful and realize that there's going to be some complications with any evictions that are already filed and with any that you give to us during the month of April that may have some delays in it relating to the stay home and stay safe issues. That being said, if you have a current eviction with our office, you need to follow the same rules that you've always followed, which is don't accept rent unless you've talked to us. We need to get agreements with the tenants. These are still pending cases. And you can still, if you take money, you can make it so we can't proceed with the cases, which we don't want to have happen. So don't talk with the tenants or take rent or anything on a case that's been assigned to our office without talking to us first. If you have an eviction during the next month that can be filed, you ought to call us so that we walk through the steps with you and make a decision whether or not we want to file the case. There may be other alternatives in talking with the tenant to try and encourage them to voluntarily move. We may be able to issue some settlement agreements, maybe even some stipulations that we file the court case and then stipulate with the tenant that will make it faster and more effective for us to get the tenants out. And so realizing that we have some delays, realizing that the courts are being a little stubborn with us right now, talk to us if you got an eviction that you'd like to have done. And we don't want to discourage it. We want to encourage it actually. And we think in most cases you should file the eviction case when it's a nuisance or a criminal activity or a end of term that you served prior to the May 27th date. March 27th date. And so we want you to file those, and you may need to file those in order to protect your rights under Utah law. So, but do talk to us so we can make sure we do it. And then just remember that notices to vacate that expire after April 1st, we need to discuss them before you accept rent again. So if you served a notice in early March for somebody to move out at the end of April, you've got to be very careful not to accept rent for May, because that will invalidate your notice to vacate, your end of term notice, particularly if you're a covered property under the federal act. If you invalidate that notice, then you can't serve another one until July 25th. And so it may be important that we file that lawsuit to protect your rights and be able to still do the eviction. And we may be able to do it in a way that is still cautious and still meets your goals, as well as letting the courts know that we're trying to follow the rules that they want. We have on our website deferral agreements, and many of you have seen those. Many of you have created your own or taken ours and modified it. I think deferral agreements are a great idea. I think they're something that we should be using as often as possible. If somebody can't make their payment and they come and talk to you about it, and it's something that you can agree to them with them on, and particularly if you're a covered property under the CARES Act, you want to get these in writing. We want to get deferral agreements. I'm a firm believer that if people sign an agreement and say they will make payments, they're much more likely to make a payment than if they don't sign an agreement. And right now, many of your tenants are thinking they don't have to do anything until the end of July. And so we want to do everything we can to encourage them to make payments, and deferral agreements will help us with that a lot. And so sign deferral agreements. These agreements are not going to change the lease agreement significantly. We've drafted ours in a way to try and make sure that you're protected in those. If you've drafted your own, you may want to have us review it to make sure it doesn't change the terms and conditions of the lease agreement to an extent that we invalidate portions of the lease agreement. The truth is, a deferral agreement for a covered property is pretty much meaningless except it could bind you beyond the July 25th date. And so as you sign deferral agreements, be careful about how long you do the deferrals, and make sure that there's provision that if they default on that deferral agreement, that it's a default in the deferral agreement that allows us to add everything back in and commence action as soon as the courts and the law allow us to commence action. Even if you're only covered by the Utah order, you're not under the CARES Act. If you're going to do deferrals for the month of April, I would still encourage you to do agreements to that effect. We get a question all the time about late fees. Do you have to waive late fees? And in Utah, the answer is no, we don't have to waive late fees if you're not covered by the CARES Act. But you may be waiving them for the month of April to get a deferral agreement signed, and it may be a good thing and a showing of good faith. And so we're not discouraging you from waiving their late fees in April. We're just encouraging you to get a deferral agreement signed if at all possible. If you get a deferral agreement signed and you're not covered by the CARES Act, so you're just covered by the Utah order, you probably shouldn't serve a pay or vacate notice after the signing of a deferral agreement. If they won't sign the deferral agreement, you can still serve the pay or vacate notice, still accept deferred payment, but it'll obviously, if you accept a payment after the pay or vacate notice, it invalidates that pay or vacate notice. But you can still serve those notices. I just would encourage you that if you get a deferral agreement, make sure it's something you can live with and not serve a pay or vacate notice as long as they comply with the deferral agreement. Now let me talk a little bit about the unemployment and stimulus money that your tenants are going to get. We've done a little research on this, and again, this is a little bit of a fluid situation, and we don't know exactly when all of this is going to hit. But as you're looking at doing deferral agreements and talking to your tenants about making their payments and what they're going to get and what they may get, this gives you some at least basis to talk with them about reality. In Utah, the minimum unemployment benefit is about $365 a week. They may get more than that. They will not likely get less than that. Under the CARE legislation, they get an additional $600 a week. And so for many of your tenants, or at least I don't know how many, but for many tenants, they may get more under unemployment benefits and the CARE benefits than they were getting as their regular paychecks. Utah's processing their unemployment claims as quickly as possible. It's still taking a little time to get them into the system. Some of them that are applying late, it could even take a couple of weeks. The federal CARE benefit, the $600 a week, will likely kick in sometime the last week of April, the first week of May. We're not exactly sure. It's just, again, it's their coordination with the state unemployment offices and how fast they can get things in place. Furloughed employees still qualify under the CARE and the State Unemployment Act based upon the CARE Act. They're using the federal legislation to enforce unemployment benefits for people that are furloughed, not just people that have been fired or completely lost their job. And so many of these people that will still have their job will still be able to get unemployment money during the time that they're furloughed as a result of this COVID-19 problem. That likely will continue through the end of July and maybe longer. We just don't know exactly how long they're going to do it. But for right now, we know they get it at least in July. People that are self-employed can also apply now for unemployment benefits and the CARE benefits. It's a little bit more of a hoop they have to jump through to get it, and it may take them a little bit more time, but by mid-April, everybody that's unemployed, even if they were self-employed or contracted employees, should be able to get unemployment benefits through the state and through the CARE Act. And so part of the reason that we picked this May 15th date, the governor picked the May 15th date, is that's kind of the date that we feel like everybody should be starting or had received all of their unemployment benefits. It's also when we think that most people will have already received their stimulus money. We think most of the stimulus money will start being received by mid-April. And just so you can kind of see what it is, a single person gets $1,200 of stimulus money. A married couple gets $2,400 of stimulus money. Plus they get $500 per child. And that's if you're single or married. If you have a dependent child, you get an additional $500 per child from that stimulus package. That is reduced somewhat depending on your incomes. For instance, a married couple, if they make under $150,000, they will still get the entire amount. It starts getting reduced for every dollar they make above $150,000 until they reach $198,000. An individual has the same thing, $75,000, and it starts getting reduced for every dollar they make above $75,000 until they reach $99,000. A head of household, which would be somebody who is single but has children in their household, can make up to $112,500 and still get the full stimulus money. Starts getting reduced after that amount until they reach $136,500, where they'll receive nothing. So you can kind of gauge that your tenants are going to be receiving some money during this time period. By May 15th, most of them will have received their stimulus money, and if they moved quickly enough, they'll be receiving their unemployment benefits by that point in time. And so as you're discussing how they're going to do their deferral agreements and how they're going to make their payments, keep this in mind, because this is something that can help you understand what they will be receiving or should be receiving. Now, I'm only going to talk one thing on student housing. I know some of you here are on student housing, and I'll try and get with you. Just remember, there's no requirement to allow somebody out of a contract merely because of this pandemic. That's true student housing and everywhere. There is nothing about the COVID-19 in and of itself that allows people to terminate their lease agreement. Reasonable accommodation may still apply, and that's on a case-by-case basis. And so if somebody comes in and makes for a reasonable accommodation request to get out of their lease agreement, we follow the same types of steps that we would have followed before the COVID-19 to make a determination whether or not they qualify to get out of their lease agreement. For those of you who deal with any of the BYU students, BYU is only suggested, not required, that landlords allow their students to get out of their lease agreement. Most of these are going to mediation. We're seeing lots of crazy letters down in BYU from attorneys and other people claiming why they should be let out of the lease, things like, and most of them just aren't applicable. Most of them don't understand Utah law. Most of them from out-of-state attorneys. If it's not a reasonable accommodation request, I just don't think you need to let them out of student housing at this point in time. But again, we should be looking at these on a case-by-case basis. All right, so what do we do between now and July 25th, this 120-day period? Well, management needs to know what each resident unit intends on doing. You should be actively communicating with your residents. Even those that come in and pay their April rent in full, you ought to have an idea of what's going on in their lives and why, making sure they're going to make their payments. And I know that sounds like a big task, particularly if you have a huge community, but we need to get a grip on what's going to happen and who's going to be a problem and who's not going to be a problem. Particularly those that if they haven't paid. If they haven't paid, we need to know why they haven't paid. If they haven't paid and they haven't signed a deferral agreement, that should be your top priority, is what's going on, and trying to talk with those people to find out what's going on. If they made a partial payment and haven't signed a deferral agreement, again, our top priority should be talking to them to find out why they didn't pay in full, how they're going to pay it in full, reminding them that this is just a deferral, that they don't get out of their rental agreement, and we don't want them to fall 2 and 3 months behind, because that's going to end up with an eviction sometime right after July 25th if they don't. Just remember, if you're not getting communication from them, even after you make phone calls and stuff, you need to use some delinquent notices to try and get their attention. This may be a full April task. This may take the entire month to get a grip on what your tenants are going to do. But you ought to create some kind of spreadsheet or something that lets you know who your problem tenants are going to be and who your problem tenants aren't going to be. And that's pretty easy to categorize. You've got the ones that you have paid in full, those that have signed a deferral agreement, and those that haven't. And out of those three categories, you kind of know what your problems are going to be and where you need to focus your time. And don't wait. Be aggressive on this. Call the tenants. Send them emails. You know, you need to find out what's going on. I don't have a problem. I mean, we're already on April 6th right now. And so those that we're going to pay probably have already paid. And those that haven't paid, you probably ought to be getting ready to make the phone calls this week and find out what's going on. And then use this time to update information. Check their applications to see how current they are and how complete. When you're talking to these tenants, you ought to have that information in front of you and make sure you're updating it. If they lost their job, if they've just been furloughed from their job, if they do they have a current emergency contact? Do you have more than one emergency contact? You know, we have a renewal application on our website that you can use to kind of fill in the blanks on this. And if you get them to sign deferral agreements, I'd encourage you to use some kind of mini application along with that deferral agreement to update their information. And you can require this to some extent. You know, particularly if you're going to sign a deferment agreement with them, you can require them to sign a new application and give you updated information on it. You also need to be thinking about what your policies are going to be, about what your policies you're going to create. And this may require discussion between management staff, maybe even your regional management staff. When are you going to serve notices? What notices are you going to serve in July? We're kind of watching this situation with you, and we're going to help you by creating some new notices for you the further we get into this. Do you know what you're going to do if you have a significant number? Or what are you going to do when people start leaving, if they do, and skipping? You've got to evaluate your residents to determine what you're going to do with each one of them, and watch your delinquencies. You know, it's an interesting time because we're concerned both about occupancy and about delinquencies. And I don't think that our occupancy is going to drop significantly, but we saw in 2008 when we had other crises going on that many people left to live with their parents, and some families just joined together, and so they got one apartment for two families. And so we may have some dips in occupancy here, and you need to be watching that and making sure that the policies you create aren't policies that are going to affect your occupancy rates as well as your collection rates and your delinquency rates. We ought to be aggressive during this time period, though, this 120 days, on other lease violations, particularly with the people that fall into the non-payment category or the non-communication categories. Talk to us, and if you think that you've got lease violations that may be sufficient to evict, then let's talk about it. Make sure we serve the notices properly, and we can help you do that. It's a time to help us clean house a little bit here and look at what we're doing without, again, keeping in mind that we don't want to get into a problem with our occupancies. And then be a little careful with your new residents as they come in. We still have people out looking for apartments. You're still going to have vacancies. But remember, a new resident signs a lease today. If you're covered by the CARE Act, this new resident's covered by the CARE Act. And so they could sign a lease and give you a check to pay it, and the check bounces, and we may not be able to evict them for non-payment of rent. And so you want to get certified funds. You want to make sure a new tenant that's coming in may have a higher deposit that comes in certified funds. You want to make sure that you get prepaid rent or something to protect yourself for this next 120 days with these new tenants. But I definitely wouldn't be accepting non-certified funds for their first month's rent, because you may get stuck with somebody for the next 120 days that you can't evict for non-payment of rent. The same with renewals. As you've got people coming up for renewal, you need to be careful and look at that and decide whether you want to renew their lease or not. You may not be able to serve them a non-renewal notice until July 25th, but you don't have to renew everybody that comes up. You can do renewals, though, for maybe just do a 2-month renewal or a 3-month renewal and increase their rent. So look at the tenants as they come in and make sure that they're current on their obligations if you're going to sign a renewal. Make them bring in certified funds for renewals. Let's make sure that the money that we collect is money that's good money, and that we're not signing agreements with bad money, with bad checks or non-certified funds. All right, let me get to some of the questions that we've already had, and that I'm going to answer as many as I can, and then we'll get to the other questions as quickly as possible. We get asked all the time, are we an essential service that we can stay open? Is an apartment management office an essential service? In most cases, the answer to that's going to be yes. You may have certain employees that are not essential, and based upon your own decisions in your community, you may have certain operational staff that don't need to come in. If you've made a decision that for the next 20 or 30 days that you're not going to be using new leases, that you're not going to try and lease up the vacant apartments that you have, then maybe your leasing agents are not essential employees. But if you're keeping all of your services open, then under the county guidelines and city guidelines that we've seen so far, we're pretty comfortable in telling you that you are an essential service to stay open. But can you close your office or limit who enters it? Obviously, the answer to that's yes. This is a management decision. You need to be safe, and you need to be careful as you can in your offices. And so to the extent that you are going to be having your office open and working, I have no problem with you locking the office, requiring people to make appointments to come in. Both tenants and new tenants and prospective tenants should make appointments. And you can put signs on your doors that state such that the office is not open to the general public at this point in time, and that if they need to talk with management, they can do so telephonically, and if they need to meet with management, they need to call and make an appointment. Do you still have to show units? Well, you don't. Again, that's a management decision. You can decide if you're going to show your units or not. You can, again, decide to only show them by appointment if you would like. And you can put other restrictions on showing apartments. You can ask the questions to people if they've been sick, which is the next one. Can I ask people if they've been sick before showing an apartment? The answer is yes. You can protect yourselves. You can require people that you're showing apartments to wear masks if you want. You can follow any normal good procedure to protect yourself, to protect your tenants, to protect your staff from being infected. And so as long as it's reasonable, then you're fine doing that. Can I ask residents if they've been sick before entering their unit? Yes, and you should be asking that question. Maintenance shouldn't be required to go into any unit until we've made a determination that the people that are in that unit are not sick and have not been infected and are not under a quarantine. And you can ask all of those questions of the person before you enter their unit. You can ask them if they've been exposed, and anything that's going to protect your staff, you should ask those questions to make sure that before you enter a unit, that it's a safe unit to enter at this point in time. What do I do if we're told that a resident has tested positive? Not a lot. This is one of those HIPAA issues that we have to be very careful with the information that we have from other tenants. Much like you wouldn't tell anybody that their next door neighbor has, that we can't talk to them about any medical issues that we're aware of. We can't talk about the COVID issues either. And so you shouldn't be telling other people that so-and-so is quarantined, or that they have the virus, or that they've been exposed to the virus. We just shouldn't be having that discussion with third parties. Now, it's important that we let our staff know so that our staff can be careful about who they're around. And it's important that we watch those apartments. So if we know somebody has tested positive for the COVID virus, and we see them out in the common areas and doing things that somebody who is quarantined shouldn't be doing, that may give us cause to serve them an eviction notice for endangering the lives of other people. And so to the extent that you know somebody is tested positive, you can have a discussion with them about staying in their unit and being careful about it, and making sure that they're not a public health hazard to it. But we don't tell other residents. What do I do if a staff member has tested positive? Well, if a staff member is tested positive, you may have an obligation to notify any residents or any other staff, or even people that were prospective residents, that you have contact information for, that they had contact with an infected staff member. We probably have an obligation under the current health orders by the health departments and the state health department to notify people of that. It can be a very simple notification. It can be something that says one of our staff members, which you may have been in contact with, has tested positive for the coronavirus. We would recommend that if you feel that you had sufficient contact with this person, that you quarantine yourself for 14 days as recommended by the CDC and the health departments. It's not a liability issue. It could be if we continue to allow somebody that we knew to be infected to have interaction. But as long as we had no knowledge of it, I'm not worried from a liability standpoint. But we probably do have to take some action to try and let people know that they may have been exposed and to quarantine themselves. What does the tenant need to do to prove loss of income? Well, so this is under the Utah one, the governor's order. And there's really nothing in the order that tells us what they have to do. But there's an expectation they're going to provide us with sufficient documentation to show they've been furloughed, or that they've had a decrease of income, or that they lost their job. Some of this is common sense stuff, guys. I mean, if their job was a waitress at a restaurant, you don't need a lot more information. If there's a legitimate dispute, though, if they give you the information and you still don't believe that they don't meet the criteria established by the governor, that's when the Department of Workforce Services can come into play. But call us first. Let's talk about it and see what it is. And remember, if you're worried about this issue, this is only an issue for those that are not covered by the federal law, and it only extends until May 15th. And so it may not be a crisis to wait this one out a little bit. Excuse me. As a housing provider, what is the best course of action if a tenant defers rent, but my mortgage is still due? Well, there's part of the CARES Act provides for some relief from mortgage payments. Both Freddie and Fannie are providing some deferments of payments. Now remember, it's just a deferment, just like our rent is a deferment, and your interest is still going to accrue and other things are going to accrue. But you ought to be talking to your own lenders if your inability to receive rent because of the COVID is going to affect your ability to pay your mortgage. If that's the case, you need to take some affirmative action to talk with them and see what's available to you. And there are things available under the CARES Act that may help you. And then there's going to be other things that may come forth from both the state and federal government to provide some assistance. Many of the banks have already put in some deferment programs, just like we put in deferment programs. And so you ought to be talking with your mortgage companies to do that. In a rent deferment program, is it better to spread a missed payment out over a few months, or just require the missed payment at the end of the lease term? Again, this is a business decision, and it may be something you have to look on a case-by-case basis, looking at the tenant and what they can do and what they can't do. Generally, we're recommending, though, that you get monthly payments on your deferment program, that you encourage them to make monthly payments, and that they have to make some kind of payment every month so that they are still engaged with you on this. And remember, we talked about the unemployment benefits and the stimulus that they're going to get. And so sometime in April or May, they're going to get enough money that they should be able to take care of their rent payments for April and May. And if they're on unemployment, it shouldn't affect their ability thereafter to pay until we see this crisis ends. And so help them look for other opportunities. There are other people out there helping. Obviously, the churches still have some ability to help, and there's other programs out there for your tenants, and you ought to look at all of those to see if it can't help them. But we would encourage you not to have lump sums, even though we had that in one of our agreements. We think the lump sum is problematic, although it may be the only option that some of them have for the month of April. Is to make a lump sum payment in May because they can't make any payment in April. Can a housing provider use a security deposit for missed rent payments? And can you then require them to replenish the security deposit? Well, this is really a look at your lease. If it contains provisions on how your security deposit can be used, then you ought to follow what the lease terms say. In our lease agreement, security deposits can immediately be used for missed rent payments. And then you're required to either send them a notice that you use the security deposit and ask them to replenish it. Or you could have it in your deferral agreement that that's what you're going to do. And we have that in our deferral agreement that says we're going to use your security deposit, but then you're going to make payments, and these payments will also replenish your security deposit. We have a notice up on our website that makes demand on the tenant to replenish the security deposit. The problem with this is if you're covered under the CARES Act, you probably cannot require them to replenish the security deposit and evict them for it. You can require them to replenish the security deposit, but you can't evict them for their for their refusal to do it, because it has the appearance that this deals with the payment of rent, because we took the money to pay the rent and now we're going to use the security deposit. So it's a business decision whether to do this or not. It does free up some capital for you that's just sitting there not being used, but there's some risk in it, obviously, that you've used their security deposit and you don't have that as a backup any longer. So once you decide what you want to do, you can call us and ask us, and we can help you make sure you do that properly. Is COVID-19 or any of the economic fallout from the pandemic cause to terminate a lease? There's nothing in and of itself that allows them to terminate their lease through the COVID virus. None of the laws allow for it. This goes back to the reasonable accommodation issues, and that if somebody comes forward with a good reasonable accommodation request that might meet all the requirements, then we might have to let them out of their lease agreement. But it would only be tangentially related to the COVID. They still have to have a disability. That disability has to be something that is that substantially limits one or more major life activities, and then there has to be a direct nexus between that and their request, which is to get out of their lease agreement. We've seen a few of these come forward, particularly some of the ones in student housing, where one of the persons in a 6-person unit has some kind of COPD, lung disease or something like that, and their doctor thinks that staying in the unit with 6 other people would be problematic because of their disability. And so you've got to put all the pieces together, though. And so they still have to be disabled. They still have to have a nexus. Other than that, there's probably no reason to let them out of their lease agreement merely because of the COVID-19 or the effects of the COVID-19 virus. All right. Well, that's the entire part of it. It looks like I've got about 20 open questions here that we're going to try and get to. Brenda, if you can hear me, if there's any order, I'm just going to take them from the top and work down on it. One of the questions is, well, if this tenant is not affected by COVID-19, would it still be okay to charge late fees, or are you advising not to charge late fees due to the fair housing concerns? The answer to that is basically that if you're covered by the CARES Act, you can't charge the late fees. Doesn't matter. If you're not covered by the CARES Act, you can charge the late fees, even if they're affected by the COVID-19. And so it really is more of a state issue. Are you covered by CARES? And if you are, you can't charge a late fee. If you're not covered by CARES, you can charge a late fee, even if the reason that they can't pay is the COVID-19. Okay, another question. Do you suggest blocking online residents from e-checks since now they're late? This is a little bit more problematic. If you're covered by the CARES Act, I don't know that I would block anybody from making payments because any money coming in is better than no money coming in. And since we can't serve pay or vacate notices, then you just want to get the money in. If you're not covered by the CARES Act, then obviously once you've served a pay or vacate notice, you may want to block them at that point in time until they come in and give you a deferral agreement of some kind. But you still need to block payments if you're serving them eviction notices that are non-related to non-payment of rent. So if it's a nuisance notice or a criminal activity notice, or if you had previously served an end of term notice, then you need to make sure you block it at the end of that end of term notice so they don't make their payments on their electronic payments. If someone skips between now and July 25th at a covered property, property covered by the federal act, are we then allowed to charge concession chargebacks and late fees? That's a really good question. I would say the late fees are probably not chargeable, but the concession chargebacks at that point probably would be, as long as they weren't related to that monthly chargeback. So if the concession chargeback is a general concession chargeback, you probably can charge it. If it's a monthly concession chargeback, you can't charge it for the months that they skip, but you can add in the market rate rent for the future rent until you re-rent the premises. And so that's a good question. And kind of in conjunction with that question, if somebody skips and owes you money, that's just a new collection lawsuit. Those are not governed by the CARES Act. They're not governed by anything. And so there's nothing to prevent you from gathering the documentation, making sure that you send out the security deposit disposition on a timely basis, and then following your normal process to process that for collection activity, because there's nothing that prevents that at this point in time. If someone takes advantage and does not pay their rent till May 15th in Utah, at that point, can we evict them? Well, remember, if you're only covered by the Utah order and you're not covered by the federal act, you can serve that pay or vacate notice as soon as they miss their payment. You could have served it today. If they make a partial payment, then you may want to serve another pay or vacate notice and keep serving those pay or vacate notices until you can actually do the eviction. But you don't have to wait to serve the pay or vacate. You just can't file the eviction action until May 16th. And so the actual filing of the eviction action can't take place until the 16th, but you can do everything else in preparation for it being filed on May 16th. If someone quits their job so they can self-isolate, does that qualify someone affected by the COVID-19? Probably. If they are, if they had a reason to feel they needed to be quarantined because they've either been exposed to the COVID virus by somebody or they had some kind of medical issues that they felt like they needed to. Under the Utah law particularly, that's probably going to be enough to let them have the extension until May 15th. But we can ask for some documentation. It doesn't really talk about quitting their job. It just says if they lose their income or they lose their job. It doesn't say they have to be fired. I imagine quitting would follow the same thing as long as they quit because of the COVID virus. It would probably fall under the same thing for the Utah law, the Utah order from the governor. Do you expect evictions to be processed slower after July 25th? I don't have a crystal ball that tells me that yet. That's a tough one to answer. I would anticipate that as soon as we start to see a break in the COVID problem, that we will see things get back to normal. As soon as we are given the opportunity to more freely associate and not feel that we are restricted to our homes, and these orders of stay home, stay safe are lifted, that we will see the processes go back to a fairly normal process. In Utah, our law is pretty specific on what the courts can and can't do. Quite frankly, the courts are violating that right now. But from a public relations standpoint, for both us and for you, we don't want to push that too hard yet. But there will come a point where we'll push it harder with the courts that they just don't have the right to do to delay these. And so we're hopeful that that will happen sooner than July 25th, but surely by July 25th, unless there's some extension of that July 25th date by the federal government. What happens if they refuse to sign a deferral agreement and you're covered by the CARES Act? Not a lot you can do. We want to encourage it, and the reason we want to encourage it with them is we want to let them know that that those that don't sign deferral agreements with us during the time that they could have will not be given an opportunity to sign any other kind of extension agreements thereafter. And so we need to use what muscle we have to try and encourage these deferral agreements. But no, you can't force them. You're just stuck with somebody if you're covered under the CARES Act. If we cannot serve an end of term or non-renewal notices, can we keep a resident on a month-to-month and charge the month-to-month fee? If we're not going to offer somebody a new lease because we want them gone, I would say yes, you can charge a month-to-month fee. This is one of those really difficult areas because it's not fully covered by the CARES Act. This doesn't relate to non-payment of rent, and we know we can charge an increased rent when their lease expires. And so can we charge the month-to-month fee? Clearly, I think we can charge it if we offer them a new lease and they don't sign it. I think it would be better for us not to charge month-to-month fees for people that we're not going to offer a new lease to. I would rather see you offer them a short-term lease that doesn't include month-to-month fees. And so if their lease expires at the end of April and you're covered by CARES and know you can't get rid of them until the end of July, really till the end of August, that you make them sign a 2 or 3 month lease in order not to be charged the month-to-month fee. Then if they refuse to sign that, then I think you're safe on charging the month-to-month fee. Can we serve an end of term notices for Section 42 properties if they aren't complying with the recertification process? My reading of the act is we cannot serve any end of term notices at all during this time period. But you can serve a notice, and maybe we need to help prepare this for you, a notice of default in their lease agreement for failing to certify, and then on the 25th, because we've already given them notice they defaulted by failure to certify, then we can serve the end of term notice at that point in time. But it's pretty clear under the act that even the Section 42 units, we cannot serve end of term notices. As this applies to Utah housing and stuff like that, they're not going to be able to hold our feet to the fire for having non-compliance in this, since we don't have any mechanism to do an end of term. We may be able to serve a nuisance notice, though, comply or vacate notice for their failure to recertify. And that wouldn't be exempt under the CARES Act, but an end of term would be. I'm getting a lot of owners that aren't sure if their mortgage is federally backed. What's the best way we can educate them easily to check and see if they are federally backed and touch loans? Well, the first thing they can do is just call their mortgage companies to find out. All of them know what it is. We also have a website that you can go to and type in an address that tells you whether or not the loan is with Fannie Mae or Freddie Mac. I don't know that you can rely upon that 100%, but that would be a good place to start. I'll have Brenda or somebody, Kirk Jr., post that on the website today to give you that website that you can go to check individual properties to see if they are have a federal loan. The problem is the Fannie Mae and Freddie Mac loans, it's not just if they have a loan with them, if the loan is guaranteed by them, if there is there's several factors that even if the loan isn't with Freddie or Fannie, that you may still be obligated because of other factors dealing with your loan. Even if your loan originally wasn't with Freddie or Fannie and your loan servicer sold it to Freddie or Fannie, you're still obligated under the CARES Act. And so you've got to really find out whether or not your properties are covered by this or not. And it's critical for us because if we file an eviction, we're going to have to file an affidavit with the courts that say you've done the investigation to determine that they are not covered by the CARES Act. What happens if we have a skip and they left the property on March 31st? Are we able to file a collection case and charge a late fee? again, if you're covered by the CARES Act, it doesn't deal with collections particularly. It deals only with charging late fees and evicting based on those late fees. And so I would say probably the answer is if they skipped in March, you can still charge them future rent for April, May, and June for their non-payment, and you can charge them the late fee for March because they owed the rent if they didn't pay in March. And so the collection action is different than an eviction action not covered by the CARES Act. How long would you say to do the deferred payments? What if they can't pay May's rent? How do you set those up? Well, look, if you're covered by the CARES Act, I would encourage you not to do payment schedules beyond the end of August. If you feel you need to do them longer than that, I definitely wouldn't do them longer than the lease agreement that they have. And so, you know, I have some clients that have decided to take the remaining months that they have in their lease and take April's payment, divide it into that number of equal payments, and just add it on to their rent for those months. I'm okay with that. I think that you ought to shorten it up a little bit. I think that you ought to encourage them to pay their April rent and their May rent with the money they're going to receive from the stimulus and from their unemployment. But again, this is a case-by-case analysis. You've got to talk to the tenants and find out what their situations are like and do the best that you can for them. We're very hopeful this is going to open up on July 25th. And so there's really no reason to obligate yourself much beyond that July or August date on these payments. But if you're going to, then just make sure it makes rational, good business sense to give them those extensions of times longer than that. If they can't make April or May's rent, I would still do your deferment agreement for April 1st, and then see in May if they can't make their May payment, and then do a second deferment agreement, wipe out the first one and do a second deferment agreement that includes both months' rent. Again, keep it as tight as you can on the payment schedules, realizing they should be getting money in April for the stimulus, and at least by May on the stimulus and unemployment. What if one person loses their job but the other still has income coming in? Of course, this is where you've got to do this analysis a little bit better. If they qualified because they both had income and now only one of them has income, your deferral agreement can talk about this. And particularly, again, if you're covered by the federal CARES Act, it doesn't matter. You're going to have to do some deferral agreement, because even if they had both of their jobs and decided not to pay their rent, there's nothing you can do until July 25th. If it's just a Utah issue, then they have to establish that they had a decrease in their income as a result of COVID, and they're going to get that extension until May 15th. And so I would work with them even if only one of the persons in the resident lost their income, because that's still going to qualify under the governor's order for Utah. And you're still bound by the CARES Act if you're a covered property. If you're covered by the CARES Act, what do you do if you can't get hold of a tenant for them to pay rent? Well, again, you've got to look at these apartments and decide, have they skipped? We're going to go investigate. You're going to knock on the door. You're going to open the door to see whether or not they're still living there or not. Particularly for the next 45 days, people should be home more than they've been. We've got a stay home, stay safe order out there. And so unless they're at a job that is a job that they're entitled to go work at, a lot of these people should be home. If they're not at home, it means they're working. And so you may have to try and get hold of them after work hours. But if you just absolutely can't get hold of them and don't know what they're doing and they haven't paid rent, by the end of April, we probably ought to be having a discussion to help you decide what to do. And some of these would be the notices that we've prepared for you to serve, the delinquent notices, and things like that. If we have a tenant claim to have tested positive in order to qualify for the deferment, are we allowed to ask for those test results? Remember, under the Utah law, all they have to show is they have a decrease in income or lost their job as a result of the COVID-19. And so if they can show you one of those two things, we really don't care about whether they tested positive or didn't test positive. They just got to show that they can't go to work because they have some order or a reason that they have to stay home. You're going to have to be pretty loose about this, I'm afraid, for those of you who are just governed by the governor's order. Pretty much somebody that comes in and or gives you enough documentation or reason to believe that they've lost their job or not going to their job, you're probably going to have to take their word for it. And you can ask for some evidence on this, but you know, a call to their employer that says they're not going in is probably going to be enough. When we do walk for skips, when do we do walk for skips if we aren't serving 3 days? You know, I'd still treat this just as business as usual. You ought to be looking at apartments that have not paid their rent sometime around the 8th, 9th, and 10th of the month to see whether they've skipped or not. And that may, if you haven't heard from them, if they haven't paid their rent, that's probably where you're going to serve your first notice, is sometime around the 6th, 7th, 8th, 9th of the month that says they haven't made their payments. And so I don't have a problem with you serving these notices on them during that period of time. We need to be a little careful on serving these notices. These are not technically legal notices where we're required to post on their door a 3-day notice to pay or vacate, or a notice to vacate or something like that. These notices that we're giving you that are just notices of default in their payments probably aren't legal notices. And so more likely we're going to want to post those by putting it in an envelope and taping them to their front door inside the envelope, not posting them face up on the door. And so these delinquent notices that you're giving to them aren't legal notices, and so we don't want to be posting them face up for people to see as they walk by, because they aren't technically legal notices. We want to be a little more cautious about how we serve those notices. In a month-to-month tenancy, you guys are really hanging in there. I appreciate it. I lost that one, Brenda. You have to bring that last one back. I didn't see it. What about if they want to cancel their lease for losing their jobs? No. Losing their job is not a reason to cancel their lease. You can still work with them. We can still do settlement agreements with them just like we do anybody else, but we're not going to just cancel a lease because of the COVID-19. They're going to have a reason to do it. And if they are going to do it and we're going to agree to do it, it's because we signed a settlement agreement with them. What would be the best way to handle a new lease that started on March 14th, but the resident never moved in due to COVID? The resident believes that we should cancel the lease, did not pay their prorated rent for March, and has not paid for April. Whitley, I don't know how to answer that, because I don't know if you're covered by the federal act or not. If you're covered by the federal act, there's probably just not a lot you can do, but they still signed a lease agreement, and there's no reason why they couldn't have moved into the premises. And so what you want to do with that is probably communicate with them and say, look, you're still bound by this lease agreement. If you're not going to move in, you need to give us notice, so you're not going to move in, and we will put it back on the market, but you're going to be responsible until we re-rent the premises. If you're not covered by the CARES Act, then under the state one, you can serve a pay or vacate notice because they didn't pay the rent for March. It doesn't deal with April's rent. All right, I think I answered all the questions that were there. Oh, one more. Well, there's a couple more, sorry. If a resident has a guarantor and says that they've lost their wages, would the documentation provided be valid if the guarantor is still receiving income? Again, yes, if it's a state one, because one person has lost their job or had a reduction of income, even though the guarantor hasn't, it only requires one of them to. If you're covered by the CARES Act, it doesn't matter if you have a guarantor or not. You're still restricted from serving the pay or vacate notices. Can we charge a posting fee if we're posting a delinquency notice? Probably not. If you're covered by the CARES Act, any fees that we would be charging them related to non-payment of rent, you can't charge. And so the delinquency notices would not allow you to charge a service of notice fee, because these are not technically legal notices that we're serving. These are just, we hope it helps us notice. What if they have completed the application, paid deposit, and administrative fee up front, but then have to back out due to the COVID-19 and travel restrictions? Do we have to refund the administrative fee, or do they forfeit that as usual? Again, they haven't signed the lease here, but they have an obligation to finish the lease, and they decided not to finish the lease. So whatever your agreement with them, whatever they signed, you would be entitled to. We don't care that the reason is the COVID-19. We don't care that that's the reason. There's an argument of what they call impossibility, and none of these are impossible. We see this in student housing a lot, that they're saying there's a frustration of purpose, that the whole basis for the contract was so they could go to school for the student housing. No, the whole basis was to provide them housing. The fact that they were going to school while they had the housing is the second tier of it. So we're not really looking at frustration of purpose, because our purpose is to provide housing. And as long as we can provide that housing, then it's not impossible and it's not a frustrated purpose. Can we deliver a small balance notice? Yes, just like you always have, and you can put it in an envelope and stuff like that. Remember, it's not a legal notice, so we don't post it. We're just giving them a small balance notice. Are there any cleaning or notification requirement for units that were turned over? Well, as far as we know right now about the COVID-19, it dies on surfaces after a certain period of time. And so any normal cleaning that you do is going to take care of the COVID-19. And my guess is by the time you've cleaned it and turned the unit, you'll have had more than 3 or 4 days. And there's not much evidence that it lasts on surfaces longer than that. And the surfaces that does last longer than that are the hard surfaces that we would have cleaned anyway. And so I'm not too worried about giving notice to anybody. We just don't know. You kind of have to look at this the same way you'd look at anything else. If somebody was sick in the apartment and they moved out, do we have to give notice to the new tenant that somebody in there was sick before they were moved in? Or, and the answer is no, we don't have to do that. Can we charge the tenant an administrative fee for our time in creating the deferral agreements? No. Again, I say no. If you're covered by CARES, the answer is unequivocally no. If you're not covered by CARES, then the answer is probably yes. You could charge an administrative fee for that. But administrative fees anything that related to the non-payment of rent, if you're a covered property under the CARES Act, you cannot charge. Well, it looks like we've gotten through all of the questions right now. I'm sure you still have lots of them. And as the days come, I'm sure we're still going to have lots of questions to do. I appreciate you being here today. I appreciate you listening to this as long as we've gone. I know it's been about an hour and a half, and we've kept almost 500 of you out of about 650. And so I appreciate you staying on and listening to all of these that we have. One more question was, are there penalties if we violate the CARES Act? And the answer is yes, there are penalties if you violate them. I can't remember exactly what they are. They kind of agreed that for the month of April, they're not going to charge any penalties, but they won't let you do it. And so you've kind of got a month to get your act together here, but don't do anything stupid. Pretty much since you've been on this seminar, you're going to be held to the standard that you should have known what it is and what you shouldn't do. And so don't do anything that we've told you not to do on this one. And if you have questions, call us. This is going to be a tough couple of months here. Hopefully by the middle of May, we'll be seeing the light of day again and be able to know where we're going to be headed with this. Hopefully when we actually see the light of day, that we can get the federal government to take this CARES Act and remove some of their 120-day restrictions and bring it down to something that's more rational and more reasonable. And I think we'll know a lot more in the next 15 days. Our office is very interested to know where you're sitting on this. And so as you have an opportunity by the 15th day of this month, we're likely to send out a little questionnaire to you just to find out what percentage of your people have not paid, who is on deferment agreements and stuff like that, so we can kind of let everybody know where we think this is sitting. And I think it'll be good for us as an industry to communicate well with each other, to know what everybody's doing, so we can get our best practices going with this. Well, if there's no other questions, I appreciate it. We'll have this posted by the first in the morning. So if you have people that were not able to watch this live, they can watch it starting tomorrow, and we'll have it up on our website. And we'll continue to send out notices to you and updates. If you haven't been receiving our notices and updates, it's because we don't have a good email address for you, and you may want to go online and check the information for your community and make sure that we have the most current information for you, so that you get all of the information as we put it out as quickly as possible. Thank you again, and we'll talk to you next time.